Good evening and welcome everybody. This is the last event for this term of the King's Forum on International Dispute Resolution. As you can see, we film many of our events, sadly not all of them, but some of the speakers would prefer to speak off the record.
I wasn't asked.
Yes, you were asked, and you said
Okay.
you're perfectly fine with being published, which I prefer. But if you go to the website, you'll find a list of the past recordings, including topics like the Tribunal for the Law of the Sea and current developments in the tribunal, or the demise of the SADC tribunal. Today's talk is going to be on regulatory space in bilateral investment treaties. And today's speaker, and I'm very happy that he was able to come, is Broude, who teaches at Hebrew University of Jerusalem. In fact, he doesn't only teach at Hebrew University. There's a long list of universities where he does teach and has taught, including Toronto, British Columbia, Georgetown, Johns Hopkins, Bocconi, and so on and so forth. In fact, I think since then a couple of other universities have joined the elite group, including Fordham and UCLA. He graduated with a doctoral degree from the University of Toronto. He's now the Sylvan M. Cohen Chair in Law at Hebrew University, and he's also on the indicative list of governmental and non-governmental panelists to hear WTO disputes. But tonight he will speak on BITs, straying a little bit from his favorite trade law topics. I'm very happy to have you here. Welcome to King's College.
Thank you very much, Holger. It's really great being here and having this opportunity, first of all, to wear a suit, which isn't something that I do quite often, but I thought it was de rigueur in London. And also this opportunity to present what is essentially a work in progress, which also means that we have a deadline, me and my co-authors, for the 31st of March, so it better not stay in progress for too long. And this is based on a paper, so it is a paper that wasn't distributed in advance to technical issues, I suppose, but also just my lateness and tardiness. So I will be essentially presenting the research that is in the paper with the slightly provocative title of "Who Cares About Regulatory Space in BITs? A Comparative International Approach." And I should first say that the title itself is really a double entendre. In other words, I'm not doubting the fact that there are those who care about regulatory space in BITs, or there isn't a normative statement in the question implying that we shouldn't be worried about regulatory space. It is really very much an empirical question on the basis of revealed preferences as we see them in renegotiated BITs, who actually does care about regulatory space in BITs. So I have to position myself in a way where I can both see the presentation and have some eye contact with the audience. So maybe I should take a step back. And I will be glancing to my prompter. Just think of Obama, looking left and then looking right. So that will be the. But here the prompter is visible. So this is, as you saw, I have two wonderful co-authors in this project, both of whom are political scientists or international relations scholars. Yoram Haftel, my colleague from the Hebrew University of Jerusalem, and Alex Thompson from Ohio State University. And I guess I'm sort of the third wheel in this project in the sense that I am the lawyer. So I wouldn't venture into this kind of research, frankly, on my own. I mean, I do have a social science background, but I wouldn't do the kind of quantitative empirical work that we undertake in this project without those who actually know what they're doing with the numbers and with the statistics and with recognized methodologies. I'm assuming everyone in the room is of the legal persuasion? That's all right. There's no one tainted with political science or international relations research and methodology. So I do serve to some extent also as a bridge within this project, and I think that it's the way to go. It's to do collaborations that are interdisciplinary, but build on the various strengths of the different people who are involved in the project. So. This particular paper is in fact a convergence of three separate issues, or three different topics. The first is a project, and this is perhaps the less important for this paper itself, but it is a paper that will be published as part of a collection of essays within a project entitled Comparative International Law. It's a project, a relatively new project that's been initiated by Anthea Roberts, who I'm not sure where she is now, but at least...
fine country district.
Okay, so formerly of LSE, is that the... formerly from this neighborhood, certainly. Paul Stephen and Pierre Verdier and Mila Filstig from the University of Virginia. And this is a project that will also, unfortunately not this particular article, but there will be a collection of essays in the American Journal of International Law and also an edited book. And their concept is to apply comparative law methods to examine international law, which is actually something that I think international lawyers do quite a lot, right? And we see how the law is applied. If it's, let's say, international humanitarian law, how is it applied by different domestic courts, even though it essentially is the same law. And the international law, objectively, from the perspective of the international law sphere, should be interpreted the same, but we do see different traits and different characteristics, let's say American, UK versus Germany, right? And of course, third world approaches to international law. That generally is their project. In this paper that we have introduced to this project as well, we're actually interested in comparative lawmaking, not the way the law is applied, but how different states engage in making law, international law, ergo through treaties, primarily treaties. When these treaties, if we're talking about bilateral investment treaties, in principle, you know, certainly to the layperson, they all look the same. And they're all doing the same work. I mean, they're all there for the same purpose. So they are equivalent. They are equivalent norms. They are parallel, but they have different content. Okay? And the devil is in the details. Okay? So we take treaties as an expression of, as I said, the revealed preferences of parties in the law that is going to bind them in the future. So it is comparative treaty making within that project of comparative international law. The second strand, which really is the major part of this project, because it is a text coding project. It's part of the so-called empirical turn in international legal research, and there is quite a lot of empirical quantitative work with respect to bilateral investment treaties. One reason is that there are so many of them, right? And you immediately have a large N. Right? You have a very large number of cases. Increasingly, we also have better access to awards and to ongoing cases and information about the arbitrators. So this is very attractive to the numbers people, right? Because they have this large database. But our work here is also different, and there's been a lot of work on the effectiveness of BITs. Do they really promote investment or not, assuming that that is what they are there for? The outcomes of arbitration, are they tilted toward investors, or are they biased towards states, and so on? The size of awards and effectiveness also in the terms of execution. There's a lot of empirical work on that. Our work here is also different because we're not necessarily looking at the cases. We have to be informed by the cases because the way we interpret the treaties cannot ignore the way the parties or arbitrators have interpreted the treaties, but we're really looking at what's in the treaties themselves at face value. Right? So we're quantitatively coding various aspects of the treaties to compare them. Okay? So this is how it ties into the comparative dimension. And of course, we're not the only people doing this. I think, Federico, you're involved in the UNCTAD coding. Okay, so the UNCTAD coding, there is a very large-scale UNCTAD project for coding the texts of BITs. And this is, so it's also conducted by students here, I suppose, or yes. All right, you have, is there anyone actually involved in that, so you might be familiar? Okay, they're coding right now as we speak. Okay, so The UNCTAD project is interested in treaties in force. Right? To characterize what is in treaties that are in force, we have a comparative dimension here. We're not interested in all those thousands of treaties that are in force. We're interested only in that relatively narrow slice of treaties that have been renegotiated. In other words, we're focusing in this project on what has changed between the old treaties and the new treaties. Now, there's also a strand of empirical research that codes the text of treaties, but does it through computer algorithms. So I think this is Wolfgang Alschner who does this, and that's we can open that to discussion perhaps about methodology, but we're old school. So we actually have research assistants who read the texts, make judgment calls about the coding, and then sometimes, and of course it's cross-coded, so we sometimes come up with discrepancies between different coders, and then this is where I come in as the lawyer. I am appointed an arbitrator between the two coders so that I can get my say on what I think is the proper coding. The third strand is, of course, the ongoing concern about the restrictive effect of bilateral investment treaties, in particular, of course, investment arbitration, on regulatory policy space. And I'm going to be using the term state regulatory space, or SRS, quite a lot because we define this and operationalize it as a variable, if you will, for the purposes of the project. But, well, to cut a long story short, and you have these huge cases going back to the NAFTA cases like Methanex, Pope and Talbot, Metalclad, these are all arbitrations that also had a public policy dimension to them, often environmental or related to labor or you name it. Recently, perhaps the most celebrated would be the Philip Morris Asia case, with Philip Morris through Hong Kong filing an investment claim against Australia with respect to plain packaging. So this is a public health issue when the costs rise, and purportedly, what I've heard, it's all rumors, but we're talking about tens of millions of dollars to just reach the end of the jurisdiction stage, which, sigh of relief for public policy, Philip Morris lost on the jurisdictional stage, but of course that doesn't provide much comfort for future public policy because we don't have a substantive ruling on the legality vis-a-vis investment treaties of tobacco control measures. Okay? So, in terms of chilling effects, that still exists despite the positive result for Australia. XL Keystone, a recent notice of arbitration to the tune of $15 billion filed by a Canadian corporation against the United States under NAFTA Chapter 11 about the not receiving approval for a pipeline from the Alberta tar sands to the United States. Well, the jury is still out, as they say. It isn't even in yet. Right? But this is something that's that certainly sends signals to governments. Wait, you have to be more careful about what you're doing. Currently in Israel, which is my home jurisdiction, so we now are a gas and oil-rich country, at least in theory, and the government, the Israeli government, is trying to approve a so-called gas plan, which includes a stabilization clause of 15 years that the government would be tying its hands vis-a-vis the foreign investor, which is an American investor, and this has been taken to the Israeli Supreme Court, and there, again, the question, who cares about regulatory space? The government is actually arguing we have no choice. We have to do what the investor wants, otherwise we will be taken to arbitration under the Cyprus-Israel Bilateral Investment Treaty, which is a treaty that no one had ever heard of before until the American corporation restructured via Cyprus. So, well, here the government may not care so much about regulatory space, but other people in the Israeli public do. So it's even reached the Netherlands of our part of the Middle East, which is usually notable for other legal issues and not those that relate to energy and investment. This is, of course, spilled over, if we're talking about renegotiation or negotiation of new treaties, the debate that we could perhaps open up later on, even though I personally don't have very strong views about it, but ideas of reforming the investment arbitration system, so in treaties like well, not in the TPP, but certainly in the TTIP and in the Comprehensive Economic and Trade Agreement between Canada and the European Union, the discourse or the proposals to have an investment tribunal instead of this sort of ad hoc system of investment arbitration, and with significant changes or potential changes in the appointment of arbitrators and other procedural and substantive issues. In the TPP, the Trans-Pacific Partnership, then this is a significant issue. And for a country like Canada, which is has lost in the NAFTA, or knows at least what the costs of investment arbitration are, then the new regime under Trudeau is concerned with the inclusion of the investment chapter in the TPP. Okay, so if you bring all these three strands together, our research question here, and who cares about state regulatory space, really translates into, to what extent, under which circumstances, and by which states have concerns over regulatory space in BITs translated into renegotiated BIT clauses. Right? That was, where can we identify that it has hurt the government so much, or that the government is so interested in a change that within the context of a renegotiated BIT, they have also changed ISDS provisions to make them more amenable to regulatory space, or perhaps the other way around. Okay, now I have to, because I'm looking at the front row here, and this is a debate that we've had. In this paper, indeed, we are just looking at the procedural effects. Right? In other words, we are looking just at investor-state dispute settlement and not at the substantive rules of the investment treaties. That's something I can expand on later on, because clearly, it's not either or. You can renegotiate both. You can decide on a strategy that renegotiates just the procedural exposure to litigation and arbitration, or you can also change the rules of the game. In other words, what are the investors' rights, but maintain the procedure of settling disputes. Right? So I'm not making any strong claims here regarding the legitimacy of the system. We're looking at what states have done in practice. Okay, so what is a renegotiated BIT in our definition, and how prevalent or common is this phenomena? So we're talking about bits that replace other bits, or investment provisions that replace previously binding investment provisions. Okay, it's a signed and ratified treaty that replaces an existing mutually ratified BIT, or a signed and, where relevant, ratified amendment to an existing mutually ratified BIT. Okay? There's a lot of ratification there because there's, in fact, one of my co-authors, Yoram Hafter, has written in the past, done a lot of empirical research to show that ratification actually matters, which is something that lawyers or international lawyers might even take for granted, but it turns out that a lot of political science research didn't draw any distinctions between those that are just signed and not in effect, and ratified BITs. Now, what doesn't this include? And of course, here I'm actually preempting some possible criticisms. First of all, it doesn't include what is a hot topic these days, which are investment provisions that are currently binding. Right? When you have an RTA chapter on investment that doesn't annul, for lack of a better word, right? It doesn't erase previous existing commitments. So this might be wrong currently. As far as last I checked, then it was the case that you have a China-Peru regional trade agreement that has an investment chapter, but there's also a China-Peru bilateral investment treaty. So they both exist and are in effect at the same time. And it's an unsolved relationship, of course, right? And the investors would argue we get the maximum rights, especially if you have MFN, which sort of wouldn't apply in itself, but it adds to the logic of accumulating these commitments. And the governments would argue, no, it's the later in time and whatever is more restrictive of investor rights and so on. This is going to be a significant issue in the TPP because the negotiators haven't actually said anything significant on, for example, what is the relationship between the TPP and Chapter 11 of the NAFTA. Right? And nobody knows. And I've spoken to negotiators about this. It's something that they have left for later on. Okay, right? Because they have, 2 years, I think, to ratify, and it's a technical issue that I'm sure they'll be able to reach agreement on it. Footnote, we have the same people coding the TPP, and even though it's not binding, it's a different aspect of this project, and all the international investment agreements that exist between future TPP partners. Okay, so we're going to do the same exercise of coding to see, for example, is the TPP, does it enhance regulatory space or restrict regulatory space in comparison to this web of agreements between the, 12 potential future TPP partners. That's not what I'm presenting here. I want to focus back to what we do consider as renegotiated. Another point that we don't include are other correction or corrective mechanisms that parties might engage with that we don't necessarily see as a treaty amendment. Primarily joint binding interpretations that exist, for example, in the NAFTA, even to significant effect with the what would be the interpretation of what is expropriation, right? Does it include or fair and equitable treatment that they have, they're clawing back some of the interpretive authority of arbitrators that might have overshot, and the government say, no, this is the wrong interpretation. Now that, and there's some writing about that with Antonios Tsanakopoulos, at least the one author that I know in that relatively recent article, that this isn't clear whether it is interpretation or amendment, and there is, at least formally, there should be a difference there. So, and it's also much more difficult for us to find such joint interpretations, especially if they're off record, if they're somehow not, and it's not a very, very common phenomenon. In fact, we do include it as a flexibility. This is part of the UNCTAD coding scheme, that if there is joint interpretive authority, then that's adds some flexibility to the parties looking ahead to potential restrictions of state regulatory space. So what we have assembled, and it's harder than it might appear to have been to begin with, we have approximately 200 pairs of renegotiated bits. Some cases then we have more than one renegotiation. And this is first of all drawing on the much improved UNCTAD database of treaties, but that isn't necessarily enough, especially if you're tracing the history. In other words, you want to see, I'm saying it's improved because the UNCTAD database now is very user-friendly and it also refers to older treaties. But sometimes we've had to do some real research to find paper copies or PDFs of treaties to see, well, when was this actually ratified? It's unclear. Sometimes you have conflicting evidence, and sometimes this is on national governmental websites, and we're not restricted to English or Spanish, and we've had coders working on treaties that are just in Arabic, for example, because there are some like that, or just in French, which is actually very interesting because you see the ways things are lost in translation, because the Arabic clause was a translation of some English language clause, and then our Arab-speaking research assistant, then they translate it back, and we have to try and figure out what was the original, what is this, what type of provision is this? Now, statistically, there are 3 types of renegotiation. One is amendment by protocol, so the original text remains in force, but there's a later agreement that changes some clauses, some provisions, right? Sometimes you see the protocols are on the same date as the original treaty because the original treaty was a template and there was some negotiation to alter it, but that's not a renegotiation as far as we're concerned. We're talking about a later in time protocol. And that's quite a large part of the database. Then you have bit replacement. This is a new bit that explicitly, on an agreed basis, terminates the older bit. But the termination and the new treaty, then they take place in parallel. So it's not as if there was a decision to terminate, break everything, not have a bit, and then later on they signed a new one. Okay? And that's the vast majority of the BIT's renegotiated bits in the database. And then there's bit substitution through a regional trade agreement investment chapter, currently much less than you might think given the high salience of these RTAs, but it's just anyone's guess, but I'm assuming that this is something that will increase in the future as investment is increasingly sort of incorporated also into the trade discourse. Okay, some insights on renegotiation, and this is really mainly from the work of Alex and Yoram. How long have I been? No restrictions on my.
That's fine.
No restrictions
We want to hear your
on my
thesis.
space. That's the. Yeah, we'll get.
You have
to,
a lot of regulatory
We'll get to that
space,
too,
yeah.
but hopefully this is also interesting. So, not surprisingly, renegotiation is a phenomena that is growing, right? Because you have old style bits, and increasingly they are somehow being replaced. The first one that we've identified is a renegotiation from 1986, but as you'll see here, there is a steady rise in renegotiations. Another part of the project I hope we'll get to is to somehow associate this with model BITs, in other words, to explore the diffusion of renegotiation, comparing which are the model BITs that have been more influential, or that states that hold this model BIT are more insistent on renegotiation. So that's just just a chart for the numbers people. Right? Everyone, well, it's not everyone, but we haven't found any, really distinctive breakdowns of who renegotiates. We're talking about almost 90 states that have renegotiated, so that's roughly half of the international community of states, and they are from all over. And it's, every continent except Antarctica. That's to make what's written there more precise. However, there are states that have had a greater propensity to renegotiate. You have 15 states that account for 50% of the renegotiations, but see, they're very diverse. So you have, Belgium, you have some Western European countries, you have some Eastern European countries, you have Morocco and Egypt, China, and the United States, and they are the chief renegotiators in our database. Okay? So that's another thing perhaps to think about. It's not as if there's no regularity in that respect. An interesting insight from looking at renegotiation, and I've sort of already hinted at that, is how does renegotiation interact with the other possibility, which is termination, whether on agreed basis or unilateral denunciation. So again, in a paper that is not yet published, but deals particularly with that issue that Johan Haftel and Alex Thompson have written together. Agreed terminations, well, first of all, I should mention there are a lot less terminations than there are renegotiations. Okay? So there seems to be an overall preference for renegotiation. It's not to throw the baby out with the bathwater, so to speak. And we'll keep the bathwater, but maybe we'll change the baby, or add some soap, or choose your metaphor. So agreed terminations, all but one, and I don't remember how many there are overall, but the agreed terminations, that's when both parties agree that the bit no longer applies. These are primarily, they had at least one party that was a new acceding state to the European Union, and presumably someone in the legal department said, well, we don't need this, and it's going to potentially conflict or contradict with our EU commitments, so let's just do away with it. And potentially in the future, again, this is in the 2000s, so Lisbon, right? This is going to be replaced by an EU investment treaty program anyway, so let's just do away with them. It doesn't, in our view, reflect any kind of negative attitude towards BITs or ISDS. Of course, many, actually, it's much more common, as you'll see at the end, hopefully, at the data, that renegotiations were for the explicit purpose of just adding a clause that says, the provisions of this BIT shall not be construed as contradicting any commitments under a regional economic integration organization, right? Which really refers to, in most cases, to the European Union. So termination wasn't necessary, wasn't absolutely necessary. There were options to that. In terms of denunciations, and those of you who might follow this more closely than I do or we do, denunciations have really been limited to a number of states who have opted to do so, and this is, as pointed out by Lauge Poulsen, sort of down the road, I suppose, at UCL, has happened in cases where governments have taken a hit. Right? They've sustained a very large notice of arbitration or even a negative, an adverse award. So that can explain why they adopted denunciation. However, many governments that have also gone through or have taken hits have not adopted or opted for denunciation. So that's perhaps a missing picture in that puzzle. This just shows you the annual number of terminated bits, and you see there's no real regularity here. And I think this, again, the 2000s, you have the accumulation of denunciations in 2008 and also in 2013. But the numbers overall here aren't, if you can't see, right, the top of the chart is 14 a year. So we have less than 14 a year max in 2008. Some observations on why this might be the case, and this is also perhaps a subject for debate. I think that termination or denunciation by governments is perceived to have a potential cost, which would be sending out a negative signal to future investors. In other words, oh yes, now we have an investment arbitration, this treaty is actually working against us, so we're going to leave, right? We're going to exit the system. And that might have ripple effects on future, future investors that had no intention of filing an arbitration, but yes, they do have, they're concerned because that shows that there's a lack of interest in protecting investors. Of course, that might not be the case because you can have a denunciation program, so to speak, or an exit plan that replaces investment arbitration with other forms of protecting investors, just like a very strong investor protection law governed by domestic courts. Often termination and denunciation has some complications with survival clauses. And I think in theory, I'm not familiar with any, I think Andrew Mitchell might have written about this, but if you agree to terminate an investment treaty, you could also agree to terminate future rights of arbitrations of investors that have not yet been exercised. In other words, there's a possible distinction between investors that have already exercised their rights under a treaty in comparison to future claims, but in any case, it's unclear, right? So yes, there is some complication. It isn't necessarily a popular way to extract yourself from future commitments, and therefore this leads back to renegotiation. That a lot of concerns relating to state regulatory space don't require rejecting the system in its entirety, but learning lessons of others that others have learned and renegotiating the terms of BITs to strike perhaps a better balance. Okay, this is potentially an important point because when we got into this, then as opposed, what often happens with political science, empirical research, is we come up with the evidence to show what certain insiders already know, right? And people who follow the field very, very closely, practitioners, they read every single BIT that is signed and every single award, then we don't necessarily need this quantitative stuff. So we didn't necessarily have, and we still don't have we don't have an agenda with respect to SRS, this regulatory space. In other words, we really didn't know exactly what we're going to come up with. It's important, this is perhaps a bit nuanced, but if there's a perception that state regulatory space is always a trade-off with investor protection, I'm not entirely convinced that that's always the case. And we have seen BITs that, with one hand, they strengthen investor rights, and with another hand, then they're also strengthening the position of a government with respect to regulatory space. Right? I mean, lots of these investment treaties, they should be concerned about, let's call it abuses, whether it's under, you have to fit it into the boxes of the various substantive norms, but you really are concerned with the abuse by governments of investor rights. And that doesn't necessarily, and you want to distinguish between those cases where there's been a legitimate exercise of regulatory policy making from those that are potentially abusive towards investors. Okay, so I'm just saying that it's not necessarily mutually exclusive. And this is important as we move on, which I will do briefly, but to the coding scheme, because we had to make certain judgment calls on, well, a provision on transparency, is that Does that promote state regulatory space? Well, maybe, but that doesn't mean that it is anti-investor. Right? The lack of transparency, for example, in an example that I mentioned before about the Israeli government, the government might have an interest in the lack of transparency. So in the Israeli Supreme Court, outrageously in my view, the government has procured a legal opinion from a top US law firm saying what the exposure of the government would be under the Cyprus-Israel investment treaty, and they have presented it to the Israeli Supreme Court confidentially. Okay? Now, these aren't facts. This is a legal opinion. The reason being that they're concerned that, if it's published, then the American investor would have some inside information about investment law that their top-notch US investment lawyers don't have access to. Okay? So a government might actually have also a lack or less interest in transparency. At last, how do we define state regulatory space? And this is, of course, also contestable. It's the extent of government's ability to freely legislate and implement regulation in public policy domains without being exposed to international investment arbitration. Okay, so here there's another perhaps theoretical point. And if we're talking about a spectrum or a continuum where on one hand, for example, there is no ISDS in the BIT. Right? There are bilateral investment treaties that don't have investor-state dispute settlement. At least historically, there have been many like that. So the exposure under the treaty, you might say, is nil, right? It's zero because there is no right of suit. There is no ability of the investor to take this issue to international arbitration. Of course, from it's a purist perspective, then the government is still bound by the terms of the treaty. Right? It might have some effect in domestic courts, for example, but again, there's no exposure to international arbitration. For political scientists, this debate whether is the law binding, even if it isn't enforceable, then that's more theoretical than anything else. They're interested really in what are the real effects or potential real effects of the treaties, and this has sort of guided our evaluation of the coding. Because what we're really doing is measuring state regulatory space. Like I said, it's based on the UNCTAD mapping project. A significant caveat here is that the UNCTAD project was not thinking about renegotiation, right? Was thinking about looking at treaties in force, so there might be some detail that we're lacking there. And it also wasn't aimed at state regulatory space. Now, the coding scheme itself is really just putting in different boxes. What type of clause of FET do we have? What type of provision on expropriation do we have? But not adding this sort of value assessment or value assignment of how does such a clause or provision potentially impact on the scope of regulatory space. And there are some issues that aren't in there, and as has been pointed out to me, thanks again, Jürgen, then perhaps they should have been there. So, for example, their arbitrator appointment is non-existent or the method of arbitrator appointment isn't part of the UNCTAD coding book, and perhaps we should have it there if we think that it is relevant to any projection that we of effects, whether to SRS or not, that we would have. In the coding scheme, we assign a value to the content of various provisions, in fact, almost all the provisions in the bits, on a scale from 0, which means that SRS is significantly limited by the content of that provision, to maximal SRS, which would be 1, which in many cases, if we're looking just at the ISDS chapters, means, well, there's no ISDS. Right? But there's a spectrum of situations that I will mention. I'll talk about some examples now to show you what our thinking has been on this. Okay, this is taken from the UNCTAD mapping guide, which I frankly don't know whether it's publicly available. I don't know, but we use it in any case, and these are the categories, which of course make a lot of sense. So you see the scope from, well, what's in the preamble. So with respect to state regulatory space, if the right to regulate is mentioned in the preamble, then that would be pro or leaning towards a higher score on state regulatory space. Of course, the substantive obligations, so if indirect ex-pro is included, then that's more restricted of SRS. If it's excluded somehow, whether explicitly or implicitly, then that enhances state regulatory space, again, because it reduces the exposure in a very broad range of issues and cases. But I've highlighted the investor-state dispute settlement, which again, we have separated and focused on in this paper. So here are some examples. And again, they're all open to debate, and I'd be happy to send the paper along at some stage, at least, maybe after the 31st of March, to receive comments, because we have a detailed justification for these choices. Like I mentioned before, they're not arbitrary; they're perhaps discretionary, but they do have some rationale, and they do have some logic. So, for example, alternatives to arbitration. Right? We're talking about mediation or conciliation. There are some treaties where that is mandatory before you turn to arbitration. Now, in our assessment, mediation would open the door to greater openness, greater consideration of what, on a non-legal basis, and not illegal basis, but not on a legal basis, more a question of equity, let's say, or taking into account the real concerns of a government, then that would open the door to some kind of mutually agreed solution, as we call it in the WTO, that is more amenable to the regulatory decisions and choices and preferences of the government, as opposed to arbitration, which, of course, how you start the arbitration, you never know how you're going to end up at the end of the arbitration, and there's exposure to significant monetary compensation. So if there's no clause, in other words, ISDS is, it's very strict, you have to turn to ISDS, then we say that that is more restrictive of SRS, and therefore the value we assign is 0. Now, if there is a clause, but it's voluntary, in other words, the parties can turn to, it's almost redundant, because parties can always turn to conciliation or mediation if they so agree. So a clause like that doesn't necessarily have very strong effect, but we have assigned a slightly higher value to it in terms of state regulatory space, because the fact that it's there does provide at least some leverage to the government to say, we have agreed that we can agree to mediation or conciliation, and here is our rationale. Here's the reason we'd like that. On the other hand, if there is a clause that it makes it mandatory to turn to alternative approaches, well, that doesn't negate the possibility that it will end up in arbitration, of course. Right? It's usually without prejudice to the ability or the capacity to turn to arbitration later on, but nevertheless, it opens the door, and the investor is required to now also go through this alternative procedure. Okay, so that's the logic. And of course, if there's no ISDS at all, then that's the best for state regulatory states for the reasons that I've discussed before. Taking every treaty and every renegotiated set of treaties, one or two, if you will, at a time. Okay, so the scope of ISDS claims, this is a similar logic. If the scope of jurisdiction covers everything, it's very, very broad, then the risk of exposure to arbitration is very, very high, and therefore state regulatory space might be restricted, as opposed to other restrictions on, if it's really restricted just to treaty claims, explicitly restricted, no contract claims, and no basis beyond the substantive provisions. Then you have some exceptions or exclusions of policy areas that also plays in there. The type of consent to ISDS, right? Is it express or implied, or is it just case by case, which is almost tantamount to having no ISDS. In other words, if it really has to, it's entirely ad hoc and requires the agreement of the parties, then it just sets the potential rules of the game, but they aren't binding to begin with. And other issues here like transparency, which I've already mentioned, and that also includes amicus curiae briefs. So, we think that amicus curiae briefs promote regulatory space because, there's, at least as we see in many cases, it might be civil society that is not on the side of the investor, let's say, right? And they might go beyond the positions of the government, but they do provide, some additional support, perhaps to governmental positions, which might be in the middle of the road. Okay, so these are the values that we've assigned. At last, some results, and this brings us close to termination. Right? First of all, this is the what? I also don't want to terminate. Believe. this is the mean state regulatory space. So it's looking at all the treaties. And what we see, therefore, if the higher the value, the higher the number, the greater state regulatory space. So looking back at the first generations of bits, right? So late 1950s, 1960s, many of them actually didn't even have investor or compulsory investor arbitration. Even the classical German ones then that started, or the German BIT project, they didn't include binding ISDS, and therefore SRS comes up, or state regulatory space ends up being quite high, and then you see this real dip. The heyday of neoliberalism and Washington Consensus pushing forward BITs, developing countries, and so on. Then you do see this this drop. Sort of, what's the opposite of, well, the trough. You can't say troughing, right? You can say peaking, but you can't say troughing. So this would be what? The nadir. Yeah, right. The nadir. Well, okay, you got it. The nadiring is in the 1990s and early 2000s, and then you see a little rise, right? If you would like to imagine here, kind of. Sorry, I'm pointing at the wrong place. If you would like to see, right, sort of a bell curve, right? No, because you could project that this is on the rise, right? So we don't know from our data, but the way things are going, and there is this slight rise in the last few years because of those treaties that have been renegotiated, then the trend might be to rebalance or recalibrate, right? We don't think it's a backlash, but you do see a reversal in terms of the SRS that we have measured. To break it down and then to just show you some colorful charts in conclusion, these are preliminary results. They don't cover all the 200 treaties, only 90, and the number crunching will take place in the next, what is the date? We have a week until the deadline, right? In the next, no, but I don't do the number crunching, right? So it's, I've shifted the onus to my colleagues. So, and also, if there's any selection bias here, we're focusing, the first ones we coded were English and Spanish, but later on French, Arabic, and Russian. So there are, this isn't on a cross-regional basis. We've been encouraged to try and convert this into a cross-regional analysis. In other words, to characterize regions rather than the groups that we've identified. But this is the breakdown that we have identified. So there's one group which, like those German bits that I was mentioning, that in the beginning they had no ISDS, and therefore SRS was very high. But many of them have been renegotiated in the early 2000s, and that has significantly lowered SRS. You'll see it graphically in a minute or so. And that's about 20% of those this partial database that I'm talking about. Then you had original BITs that, to begin with, had a limitation on ISDS. This is primarily like Soviet, some Chinese, Eastern European, where the arbitration was limited just to the compensation. Whereas on the merits, it had to be dealt with otherwise. But if there was a dispute about the compensation, what the value of the award would be, then that could go to international arbitration, whereas these have been replaced by new bits that expand the scope to cover everything. Again, significantly, in our assessment, reducing state regulatory space, and that's about 20%, and that is very much associated with the end of the Cold War and the law reform projects of the 1990s. Then you have a set of treaties that, to begin with, had low SRS, low state regulatory space. The renegotiation hardly made any change. Okay? And this, again, is associated mainly with EU accessions, right? This is the other side, what I mentioned before. The other side of the termination coin is, well, we're keeping the BIT as it is. We just add a protocol that says, well, it shall not contradict EU obligations or regional economic, or EIO obligations. And then you have the smallest but very significant group, which is those BITs that have actually been renegotiated to fine-tune limitations, exclusions, transparency, to increase SRS. And this we see primarily, you could call it the NAFTA effect, or we see it primarily among the United States, Canada, and some Latin American states. Okay, so these are the results in graphic form that, to satisfy one potential critique, right, which is, why are we focusing just on the procedure when, as I said before, you can have a strategy of keeping the mechanics of the game the same, but changing the rules in a way that changes SRS. So this gives you a preliminary indication of what the substantive assessments are as well. This is an example of the first category. So you have a German BIT with Jordan that has a very high value of state regulatory space, primarily because of this, right? This is, where is it? ISDS, okay? Right, it's the icing on the cake. It's the top of the top of the chart is ISDS, and since there's no ISDS, on all values, we got 1, which is the highest range of ISDS. That was completely reversed in 2007 in the new German Jordan BIT, which does have strong binding ISDS, etc. So it got lots of zeros. But interestingly, there's hardly any change in the lower layers of the cake, right? The substance has barely changed in terms of our assessment of SRS, right? Because we have a set of, right, which I haven't exposed here, but we do have a set of valuations also for substantive rules. This is an example of the third category where you see very restrictive ISDS, right? It's a thin layer at the top, and it's been expanded somewhat in the later BIT, but very, to very small extent. Right? There's hardly any expansion of SRS in the ISDS range, but you do see in this case, in terms of standards of treatment, they have become stricter, right? And I'm not getting, we don't know enough, and people again who are in the field very much will know to say, well, maybe this is reflective of, the second generation or third generation of Chinese BITs. I can't say that with any certainty here, but here we have some numbers to that respect. And this is an example of the fourth category where ISDS has changed to some respect, expanding state regulatory space. Again, not dramatically, but this contributes to that slight upturn at the end, where you see that there are certain values of ISDS that have changed to expand state regulatory space, but not only, because we also have that category. Again, I'm pointing to the wrong place, but that category of flexibility, which are substantive terms and not procedural ones. So, right, that has made a significant contribution to leavening the cake to make it more conducive to state regulatory space, but not because of significant changes in the investor-state dispute settlement system. Okay, so these are some conclusions. A study of renegotiation cannot capture the entire picture, right? Because actually what we don't include is non-renegotiated but new bits. Right? And you could actually, I'm talking about a pair of countries that don't have a BIT at all, but their first one is sometime in 2007, and that already includes greater flexibilities or changes in ISDS, but we can't trace that in this project. Right? We're only looking at cases where a treaty has been replaced by another treaty, not where a void has been filled with a treaty. Of course, a new treaty, almost by definition, will restrict state regulatory space in comparison to the pre-existing situation where there was no BIT. Having said that, you saw this slight upturn, but we don't really see, at least up to, 2010, which is when our data, well, it's continuously expanding, of course, but that's what I've showed you up to now. We don't really see a backlash. We don't see a rejection of the entire system. You could say, well, that indicates that the system is legitimate in the eyes of governments. I wouldn't subscribe to that very, very strongly. Right? It shows that governments have gotten used to it, or that they continue to accept the unknowns that they accepted earlier on. I think there's still many governments that might not be aware of the existence of the agreements. And of course, somebody in the government knows, but it would be in a dark room in some ministry that doesn't know, the Ministry of the Environment doesn't have any, isn't privy or doesn't know what the risks of this are. And then you have the same people renegotiating the treaty, so you get more of the same. There's the idea that in some writing that some BITs were signed either out of ignorance or out of coercion, because they also don't deliver the desired results in terms of increasing investment, and therefore if you buy into that, and it's plausible in many cases, then why shouldn't that be the case in the renegotiation, right? I mean, if you have country X that is a weak government or a corrupt government or whatever, and they're renegotiating now with a very dominant country in international relations who really just wants to amend the bit so it will reflect the model, their new model BIT, well, you might expect the same effects in renegotiation, but again, that requires a deeper look case by case and so on. And I think that is where I will end, because all the rest I've also sort of discussed. Okay.
Thank you very much, Tomer. And even though we do have a reception next door, you should receive at least some questions here before you then...
And I can answer them over there.
You can answer additional questions over there. Okay. Any questions? If none, of course.
I'm sorry that I came in late.
You missed the best part.
I'm going to have to get better English. I wondered whether you looked at who negotiated, just because in the earlier negotiations, particularly for several countries outside of NAFTA, the Canada and US group, it would have been trade negotiators and policy government officials, and not necessarily a division that focused on investment. And so I wondered if maybe coming in from a trade perspective, they would have had a different understanding about state regulatory space, and that would perhaps been another impacting factor.
The short answer is no, because I think in the larger project, and this clearly is part of the larger project, and we will raise, this has been a bit, you missed the beginning, but seriously, I framed it in the context of various dimensions of another project and so on. So it's sort of tailor-made to a particular question, but in the future, certainly the political scientists will want to add the potentially independent variables that affect these incomes and to raise interesting hypotheses. And I think that would be certainly a very interesting one, even though I'm not sure how we would access or how we would know exactly how we would characterize negotiators. One hypothesis, for example, is that I think that there's been a large, and this is just speculative, but on the basis of just sort of general reading the papers, that renegotiation that increases state regulatory space has been driven by legislators rather than by the executive. In other words, where you have some pushback from the European Parliament, right, in Australia, and then you have certain pushback from parliaments that become aware of the risk that BITs might impose on future legislation, then they raise it as a public issue, and that exerts some domestic pressure to renegotiate, recalibrate, threats to leave the system, and so on. Whereas where the process is entirely led by the executive, and I would, again, thinking about Israel, when you have an executive that rules the parliament, then it's not going to get pushback from, it's going to get pushback from the opposition, but they're not going to pay attention to that. It's the government pushing forward a particular project. So that's just, I'm answering, it's pretty typical, I'm answering a question with a question, in the sense that it's just an example of other hypotheses that would have to be tested, and it's not necessarily about SRS, it's about that's a question that relates to the political process and the inner workings of decision making, and the so-called two-level game, and we're talking about the domestic game and who gets to determine what investment agreement policy is. And I think that in many cases then you're looking at a higher resolution about who in government. But think about developing countries, or not even developing countries without naming names, but some developed countries that you really, literally will have one person in the civil service who deals with this.
Yeah.
Right? Certainly a developing country, and you know what? He or she might be the same guy or gal who do the trade ones, but not because they're experts in trade. It's just, or there might be different people, and it might be arbitrary. So I'm just going to leave it as a question that I think would be, and I'd be interested to hear how you know who negotiates on a systematic basis when you're talking about, in this case, 86 different countries. And that would be a challenge because not all countries are transparent about, who leads negotiations, I think.
Yeah, I mean, I guess just because I was asking, just because of my own work, but also
Yeah.
I was at a TPP event recently, and they had some of the government negotiators there, and yeah, so Chile, a representative was talking about how, at the same time that they're negotiating that, they're negotiating all their other treaties as well,
And
a
the
lot of
same
them-
people or different
Yeah,
people?
no, exactly. People. And actually, the Chilean delegate mentioned that ISDS would be, that they don't have that much experience with investor states and stuff, and so they hope that their other treaty partners would, provide some insights into those workings they weren't aware, and they mainly focusing on.
No, I think these are.
So that's where,
That's an excellent question. I think I might add to that, and I won't mention countries by names, but there are countries where the involvement in the TPP has been led by politicians, being very receptive to the positions of other governments, whereas the civil service has been, what would be the term? Well, I haven't mentioned names of countries, but still, they have been sort of kept out of any effective influence on the process. So again, you have a higher degree of resolution there.
If I make a couple of questions, mainly going to the distinction between correlation and causation, and to the internal categories of SRS. So the way I read the changes of the Egyptian VIDs, for instance, I identify them to two. One concerns the termination and renegotiation of the Sadat era treaties, and the other concerns, in my opinion, maybe is highly affected by the signing of the Unified Arab Agreement, which also established something, and we can see that these countries indeed sort of renegotiated at the same time, Oman, Jordan, Egypt, etc. Now these two are different kinds of SRS, and I wonder if you distinguish between them.
In what sense?
In the sense that if you define SRS as to be the right to regulate and legislate, etc., then it is clearly also the right to enter into the Arab Investment Agreement and establish the Arab Investment Court, for instance. The termination of the Sadat treaties would be much like the fact that Sadat introduced Law 43 after Nasser, would be again within the ambit of SRS and within public policy and public considerations and the effects of bread right, etc. But these would be two different kinds of SRS, none of them being in any way related to ISDS, for instance. So I wonder if these are at all important. Second point being is I wonder if it works the other way around. This is to say the fact that US, for instance, has maintained a somewhat similar line within its bilateral investment treaties from, I don't know, the 80s until the recent 2012 model BIT. And it also constantly holds the position, we are not afraid we never lose a case, right? So does that mean that the US, because it's not afraid, it never lost a case? And this is also, well, rather additionally, not to draw a line of causation between the two, maintains a very consistent line of bilateral investment treaty drafting. Does that indicate that it has a wider SRS? Does it work the other way around? Third question. And
wait, one by one, because I didn't understand the second one.
Yes,
how does it work?
The other way around, this is to say,
Even though I'm used to asking the questions. No, it just.
Several questions.
Tomer used to be my, there's a very long
You can then afterwards choose to just answer one question and act as though you've answered all of them.
But no, I didn't understand.
No.
How does it work? How does that example mean that it works the other way around? Because of course you're injecting a question of, let's call it the political clout, perhaps, of a party, which is something that we should include again, as in previous answer, as a, let's say, an independent variable that might explain why a certain government is so blasé that they would not take seriously the threat of And so something that we would either control for or
What I meant is rather if we sort of operate under the postulation that renegotiation is affected or rather driven by SRS, or to some extent, not clear what, but to some extent is driven by it, then I ask whether the lack of renegotiation is in and of itself perhaps indicative of a well-established SRS and no need to them. This is sort of the question that I...
Or a lack of concern at least, which again might be explained by various different variables. Right?
Yeah,
lack
of course.
Lack of awareness or a sense of immunity. Right? And yeah.
I had a third one, and it goes slightly outside the scope of what you said, because you said you do not touch model BITs at this stage.
Right.
But if I may just sort of looking at India, that just now published a new, again, revised model BIT after it already published a model BIT, and this is clearly the result of wide industries in Balfour and whatnot, but does that mean that this is necessarily because of the right to regulate? Or is it for other purposes, for instance, I don't know, clarifying that full protection security covers only physical, much like NAFTA FTC did in 2011. And final small point, do you think, do you grade differently the location of the right to regulate? If it is in the preamble, or if it's in Chapter 8 of CETA, saying for greater certainty we have the right to regulate for whatnot?
Yeah, well maybe I'll start from the minor point at the end. And then it'll remind me of the other ones first. But the location, yes, in the same, and actually, you know, the weighting is actually quite equivalent in, let's say if it's in the preamble, then again it would be 0 to 1, and we haven't allocated a different weighting to the same, you know, to different provisions. That's something that we should do as we expand from ISDS to the substantive provisions in other parts of BITs. And that, of course, I'll have to do with number crunches, because that adds another layer of complexity and explanations and justifications. Why do we assign, you know, if it's in the preamble and it's actually 0 to 0.5, whereas if it's an operative clause, it will be 0 to 1. And it will require explanation. It adds complexity, but it's certainly something we'll have to think of. Having said that, there are lots of other things that we can't really capture, and something that I've been thinking about. There's the environmental measures clause in after Chapter 11. And there is some debate about whether it actually does any work. It hasn't done any work. Right now, you know, nothing in this agreement, I forget exactly the phrase, but environmental measures, not otherwise inconsistent with this agreement. And that's where you have the circularity that, you know, the orthodoxy says, well, this is redundant or it doesn't do anything, and I actually think that it can do a lot. Depends on willing interpretation, and that really has never been dealt with by any seriously by any tribunal, and hasn't really been argued forcefully by anyone. But
It's environmental cases.
I think it raised it in, I forget which one, maybe Pope, Esty Myers, and the arbitrators sort of, you know, they ignored it.
Yeah.
But now, well, why do I raise that? Because in the TPP, then you have in Chapter 9, which is the investment protection chapter of the TPP, you have the exact same clause, except it is now environmental, health, and other public policy measures.
Morals.
Okay? Now, so if you think that this provision does anything, then now it does much more. Right? But that, we would code essentially the same, because you have an exception, or you have whatever it is, an exclusion, right, you have some flexibility, and it would fall under certain of the clauses.
So doesn't that go against your excluding substantive matters?
No, I'm saying if we're not excluding, in this paper we are.
Ah, okay.
But
So
generally we are not, as you saw in the case.
Yeah.
You know, the layers.
So this is sort of for the next page.
Right, so this is, you know, just an example. Again, I'm answering with a question, in the sense that, yes, there's certain things that I don't think we can capture. Now, just remind me about the India example. Well, model BITs in general.
Yeah, for instance, here is another example of renegotiation
Yeah,
argument
right.
driven by public consultation or whatnot. yet no claim was made in between these two, so maybe it's not.
Right, so frankly, and this I think goes to your part of your first question about causation versus correlation, we are not making very strong causal claims, at least not at this stage. To do that, then we would have to introduce variables that, independent variables that then, and control for lots of things to actually argue for any type of causation and not just correlation. With respect to model BITs, I mentioned that it's open game. No, I mentioned that as something that I've urged within the project that we should also we should code model BITs and raise lots of other interesting questions about diffusion, for example. And there you also have the politics and who gets to which model BIT copies whose model BITs. That we can figure out quite easily, and then which model BITs get adopted. That again transcends the boundaries of our project because it relates to new BITs, and not renegotiated ones, right? Brand new relationships that are based on a model BIT. So that's something that maybe with the UNCTAD, the general. There aren't many. No, they're not doing model bits as far as I'm saying. That we want to do model BITs to see how that affects renegotiation. We're sort of outside anyway. No, we're not really contributing to it because again, as I meant, you might have been you might have walked in late. I said because we are also coding old BITs, which UNCTAD are not as interested in. They're interested in what's the state of the art, and we're interested in dynamic changes over time. So we have a much smaller. If their idea is to have, I don't know how many BITs there are today, but if they want to code every BIT IIA in effect, what the coding? In earnest, I think maybe 2000. No, the code book is actually quite recent.
No, I mean because we do the mapping project here, and I think the first round of treaties they gave us were like some of the ones from the 90s.
Okay, but they're ones in effect.
Yes.
Right, that's the distinction that I'm drawing between, we would code treaties from the 50s and from the 60s, even if they've been replaced. Actually, we code them because they've been replaced.
Okay, and I propose we now move the discussion to the next room.
Excellent.
Thank you very much for coming. That was the last event for this term. I'll announce new events then over the long summer break. One thing that we will have to announce, though, we will start a partnership with the PCA and the scholarship program to work at the PCA for a year. I hope to be able to announce that next week. Okay, thank you very much.